and jumped out and ran in the woods and threw out drugs. So, all right, Mr. Johnson, come on up. Mr. Johnson, in cause number 24, DCCR 2265, we've already gone through this, but you're charged with evading arrest or detention with the use of a vehicle. I have Thomas Johnson?
Yes, ma'am.
And Mr. Johnson, this is your initial appearance in cause number 24, DCCR 2265. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from September 8th of 2024.
Yes.
Since you've made bond, have you had an opportunity to try to hire a lawyer?
All right, pause right here. This isn't just a routine court check-in. A third-degree felony for evading arrest with a vehicle is serious business. We're talking prison-level exposure, not traffic ticket energy. And when judges hear vehicle and evading, their first thought is danger. Danger to officers, danger to the public, and danger to everyone on the road. Buckle up, because this case escalates fast.
I am not.
Okay. What do you mean when you say you've had a long morning already?
Oh, my foot. I've had some metal fall on it yesterday, so everywhere I'm going, I'm hobbling around, so it's just hard to get around on it right now.
Okay. Give me just a second to check something.
It makes for moving.
Notice how this starts small. A hurt foot, a rough morning, a guy clearly uncomfortable. But in court, how you present matters almost as much as what you're charged with. Sympathy can help, but patience runs thin when the judge is already juggling safety concerns behind the scenes.
Yeah, I'm not supposed to.
Did I test you this morning and have anything in your system?
No.
Let's double check that before we go forward. Have a seat over in the jury box, please. That, it doesn't show a state's attorney on that one.
Wait, hold on, I just got it. I just put it in.
The PC on that one,
Hold on.
the high-speed chase was crazy. I wonder whose it is. I mean, like 100 miles an hour down 105. They went from here to Hardin County and back and jumped out and ran in the woods and threw out drugs. So, all right, Mr. Johnson, come on up. Mr. Johnson, in cause number 24, DCCR 2265, we've already gone through this, but you're charged with evading arrest or detention with the use of a vehicle. I have reviewed the pre-sentence report in your case. Based on that report and the fact that there is an allegation, obviously an allegation of a high-speed, very dangerous chase, but in addition to that, there's an allegation that drugs were thrown out of the vehicle during that chase, and that's why I ordered the drug test this morning. It's now 11 o'clock. I ordered this drug test prior to 9 o'clock. You have not been able to go or refusing to go to the restroom. Based on that, I am going to find that I'm going to assume that you are positive and that it is in the best interest of our community that.
This is a critical legal moment. The judge ordered a drug test before 9 a.m., and by 11, there's no sample. In court, refusing or failing to comply doesn't stay neutral. Judges are allowed to draw negative inferences, especially when drugs were allegedly tossed during a high-speed chase. That delay, it just turned into a $20,000 problem.
I raise your bond, which is currently set at, give me just a second to figure that out.
It was at 10,000.
10,000.
Yes,
I'm going to raise your bond in your case to $30,000. A condition of that bond, if you make it, is that you wear a drug patch at all times. You will have 24 hours from the time you are released, if you make that bond, to have a drug patch put on. Your bondsman can let you know where to do that. You have to change it every 2 weeks. If it tests positive, you would be right back in custody, obviously. If it's not testable, then it's also going to be considered a positive drug screen. You can go back with the bailiff. Not today, not now. Mr. Harris on Camden Jackson.
Think about this. Bond didn't just triple. Now there's a drug patch monitoring him 24/7. That's not a suggestion. That's a surveillance leash. One positive test, one tampering issue, even one unreadable result, and he's right back in custody. Would you risk it?
Yes, Father.
Good morning, sir.
Good morning.
It's still morning, barely.
Barely. Judge, did you want?
Yes, sir, thank you. And they told you about sending the attachment in?
Yes, Sean.
Okay. Thank you, Ms. Malfino. All right, sir, are you,
And just like that, the courtroom tone flips. We move from chaos and confrontation to cooperation and strategy. This next defendant has a lawyer ready, a plea negotiated, and a judge who's willing to listen, for now. Same courtroom, very different outcomes. This is where behavior starts to matter more than words.
Camden Jackson? And Mr. Harris, will your client waive the formal reading of the indictment?
Yes, Your Honor. And apologies for my handwriting because it's horrible.
It's hard on the tablet. You're good. All right. So you're charged in cause number 25, DCCR 0114, with the second-degree felony offense of engaging in organized criminal activity from January 10th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Harris?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 7-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation, which could include me ordering you to some upfront treatment, like ISF or something like that. And it looks like that's what the state's going to be requesting. Do you understand? And that decision's up to me when we come back for sentencing. All right, Mr. Jackson, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to recite your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Before we go forward, can you look real quick, jail incident reports, and see if there's any on this one?
And Judge, I was, if I may, going to address that between January and the end of February. So obviously we've had quite some time that either they have not gotten to my file or the court's file. There were at least 8 pages full of write-ups. I would ask the court, Mr. Jackson committed this offense 6 days after he turned 19. It's obviously very serious. He was with the co-defendant, Mr. Bushnell, who's already entered a plea involving firearms, etc. I would ask if the court would consider your usual admonishment if that behavior continues pending the PSI, that I reserve the right, as does the court, to just reject this offer and possibly send him to prison.
Mr. Jackson, you're probably, I don't know if you're in the same dorm as some of the other ones that have been
Yes.
absolutely ridiculous acting up in the jail. Yes. So there's somebody, I think it was last week, that came in with a deal like this for a probation, and he didn't get it, and he's sitting back out at that jail. I do not have to accept this plea agreement. I'm going to read every single one of those jail incident reports. The disrespect that y'all are showing to the officers, I can assume what these are going to say, because y'all are all out there. It's the same group that's doing all the same thing, fighting, not following instructions, talking back, calling names. I'm going to read all of that. And let me tell you, if you have one between right now and your sentencing, I will not accept this plea agreement. I'm sick of it. The jail's sick of it. And I'm going to do whatever I can to make that place a better place for those people to go work who are out there just trying to do their job. Do you understand? One. We're not going to come in and say it was somebody else's fault. I only got 1 or I got 3 and that's not that bad. You can go out there and tell them, I want to get out and be on probation. I don't care what you guys want to do. I'm going to behave. If you have to sit on your bunk all day long and be quiet for the next 5 weeks, then that's what you do. Right? 5 weeks. Rest of your life. What do you think? Show me you can do it, okay? All right, and go back with the bailiff.
Thank you, Your Honor.
Yes, sir. Yeah, the last one was May 17th. So,
Thank you, Mr. Harris.
So it hasn't stopped.
It will stop before these,
Well,
just before night.
we'll see.
I'm threatening.
We'll see. I hope so. I hope they're having an easier time out of the jail.
That's what I'm thinking. I wonder what's up.
What's that? Wait. Yep. Thomas Johnson. And Mr. Johnson, this is your initial appearance in cause number 24 DCCR 2265.
His case carries the weight
You're
of
charged
danger
with a
before
third-degree
anyone
felony
even
offense
speaks.
of evading arrest or detention
judge
with the
listened
use of
as
a
excuses
vehicle
surfaced,
from September
but
8th of
concern quickly
2024.
replaces sympathy
Since
when
you've
a
made
drug
bond,
test
have you had an
order goes
opportunity
ignored.
to try to hire a lawyer?
What
All right,
begins as a
pause
routine
right here.
appearance spirals
This isn't
into
just a
suspicion,
routine court
and
check-in.
silence becomes
A
its own
third-degree
confession.
felony for evading arrest
As the
with a
morning
vehicle
drags
is
on,
serious
the tension
business.
sharpens.
We're talking prison-level
Allegations
exposure,
of a reckless,
not traffic ticket
high-speed
energy.
chase and drugs
And when
thrown
judges
from a
hear
fleeing car
vehicle
hang in the
and
air.
evading, their first
When
thought
Johnson
is
fails
danger.
to comply with
Danger
the
to
court's
officers,
order,
danger
the
to
judge
the public,
acts decisively.
and danger to everyone on
Bond
the road.
jumps from
Buckle
$10,000
up,
to
because this case
$30,000,
escalates
and a drug
fast.
patch becomes mandatory.
Okay.
Every hour, every
What do you
test,
mean when you
every
say
move
you've
will
had
now
a
be
long
watched.
morning already?
Oh, my
One
foot,
mistake
I've had
sends
some
him
metal
straight
fall
back
on
to
it yesterday,
jail.
so everywhere I'm going, I'm
Then the
hobbling
tone
around,
shifts.
so it's just hard to
Camden
get around
Jackson
on it right
steps
now.
forward,
Okay.
young, 19,
Give me just a
facing
second
an
to check
organized criminal activity charge.
It makes for moving.
Unlike
Notice
before,
how this starts
preparation
small.
fills the
A
room.
hurt foot, a rough
lawyer
morning,
stands ready,
a
a
guy
plea
clearly
negotiated,
uncomfortable.
and for a moment,
but in
hope
court,
exists.
how you present
But the
matters
judge is
almost
not
as
fooled
much as
by
what you're
paperwork
charged
alone.
with. Sympathy can
Jail
help,
behavior
but
matters.
patience runs thin when the
Respect
judge
matters.
is already juggling
One
safety
incident,
concerns
one
behind the
act of
scenes.
defiance,
Yeah,
and the
I'm not
deal
supposed to.
vanishes. The warning is clear and brutal. 5 weeks of
Did I
discipline
test you this
could
morning and
decide
have
the rest
anything in
of
your
his life.
system?
The
Let's
courtroom
double check
falls
that before we
silent
go
as the
forward. Have a
message
seat over in the
lands.
jury box, please.
Freedom is fragile.
That, it doesn't
Patience
show a
is
state's
limited.
attorney on that one.
In this room,
Wait, hold on, I just
choices
got it.
echo
I just
louder
put
than
it in.
words.
The
And every
PC on that
decision
one?
carries
Hold on.
consequences that reach far beyond these walls.
The high-speed chase was
Justice here is
crazy. I
not
wonder
loud,
whose it
but
is.
relentless.
I mean,
It
like
measures
100 miles an
effort,
hour down
accountability,
105.
and
They went
respect,
from
not
here to
excuses.
Hardin County and back.
One
And
man learns how
obviously,
quickly
an
freedom
allegation
tightens
of
its
a
grip.
high-speed, very dangerous
Another learns how
chase.
easily it disappears.
But in addition to that,
In
there's
this
an allegation
courtroom,
that drugs
mercy
were thrown
exists,
out of the
but only for
vehicle
those
during
willing
that
to earn
chase,
it.
and that's why I ordered the drug
Today
test this
proves the
morning.
system watches
It's now
everything,
11
even
o'clock. I
silence,
ordered this drug
hesitation,
test
and
prior to
attitude.
9 o'clock.
This is not just a case. This is a fight for justice, where one question from the judge can change a life forever. The silence of the victim, the arguments of the lawyers, and the verdict that decides the truth. Welcome to Court and Courtroom, where every case reveals a new truth, and every truth leaves a lasting impact.